Hi. Welcome everyone to Yo Soy Neighborhoods Fresno. Today is April 24th, 2020. I appreciate you tuning in, and we're all starting to do a little work here and there. I'm working all the time, thinking. Today we have a great information for what's going on right now with this pandemic. We have our labor commissioner, Ms. Lilia Garcia-Brower, and then our local deputy labor commissioner, Lindsay Frank. And today we're going to go through a few questions and share some websites and phone numbers, I guess, along the way. And what we're going to be doing is I'll let Ms. Brower go ahead, our dear labor commissioner. She's so good looking. She's so give us a kind of a quick debrief of your background. You're from Los Angeles?
I am. Yes, thank you. Thank you for this opportunity to be with you. My name is Lilia Garcia-Brower, and I am California's Labor Commissioner. I was just appointed in August of this past summer. And I am born and raised in East Los Angeles. My family, my parents, grandparents came to this country in 1956. And we settled in East LA, and we've stayed in East LA. And my father was a factory worker, and my mother was a garment worker, along with other jobs. My father's 80 years old and continues to work in a factory today. He, in fact, is an essential worker, and he is working today. And I spent the last 20 years representing janitors. Most are immigrant, many are undocumented, many don't understand their rights. And many are exploited to provide services far below the minimal standards. And I worked closely with the Labor Commissioner's office. I also worked closely with responsible employers in the janitorial industry who were struggling to have a fair marketplace. And they invested in an organization to try to alleviate that unfair competition and fight the underground economy. So I'm very excited to have this honor to work side by side with incredible hardworking people in the Labor Commissioner's office to uphold workers' rights and to level the playing field and ensure employers are following the law.
Oh, that's just wonderful. I mean, you understand, you've been there in the trenches, so you understand what these folks go through. I mean, I had a janitorial company in North Orange County, and it's difficult. It's the margins are very small. Yeah.
Right. Yeah, about 3%. Yeah.
It's tough, and it's hard work. It's not easy. So now, could you provide us with just a very short, brief overview of your labor commissioners?
Absolutely. The Labor Commissioner's Office, we are the primary enforcement agency of workplace protections found in the Labor Code and in the Industrial Welfare Commission orders. We have 18 offices throughout the state, and we have 7 different units that range from the wage claim office, where you could file an individual public claim against your employer, to our retaliation unit, to a public works unit. And so we are a resource for workers and employers to understand their rights and obligations and to resolve complaints if they have any disputes at work.
Okay. Now, that was one of the things that you mentioned there is retaliation. I think that if you could give a short debrief of retaliation, and if you don't mind, could you do a little blurb in Spanish as well?
Absolutely. So we could do this all in Spanish if you want.
Well, we have both languages, English and Spanish speakers. So
okay.
It'd be great if you do it. You could start off with whichever you'd like first and then do the other as well.
Okay, absolutely. La represalia es una acción protegida, un derecho que un trabajador tiene de ejercer un derecho como pedir pago por todas las horas, pedir tiempos de descanso, recibir su cheque a tiempo, todo eso son derechos básicos. Y la ley dice que uno tiene el derecho de ejercer, exigir esas condiciones de su patrón sin miedo de represalia. Entonces, si su patrón toma una acción negativa contra un trabajador por ejercer estos derechos, como cortarle las horas, agregarle trabajo, ponerle en un sitio que es más difícil, todo eso se puede establecer que es represalia. Entonces, si un trabajador vive esa experiencia, puede poner un reclamo con nuestro departamento de represalia. Y poner un reclamo sí es muy difícil. La obligación está en el trabajador de establecer con evidencias que uno hizo una acción protegida y que el patrón supo de esa acción protegida. Y por el hecho que el patrón supo, el patrón tomó una acción negativa contra el trabajador. So, esos tres elementos se tienen que establecer con evidencias para ganar su caso. Pero todo trabajador en California, no importa su estatus inmigratorio, tiene protecciones que se encuentran en nuestra oficina.
Okay. So, do you want to give that a little debrief in English?
Sure. So the Labor Commissioner's Office enforces anti-retaliation laws. And retaliation stems from a worker exercising a protected right under the labor code. So that is, for example, you have the right to be paid no less than the minimum wage, to receive overtime, to take your meal breaks, etc. If you exercise a right that is provided to you under the labor code, and if your employer knows about that and takes negative action against you, like cutting your hours, assigning you more work, making your job more difficult, then that can possibly be retaliation. And if you believe that you've experienced that, then you can file a claim with our retaliation complaint investigation unit, and you can resolve that issue. Establishing retaliation is difficult. The burden is on the worker to establish that, in fact, they experience retaliation. So you have to establish with evidence, which means with somebody who heard or saw something directly, or with documentation that supports what you're saying.
Can they take a recording on their phone?
Not without the other party's knowledge of recording. You can ask for permission, but there are constitutional rights that apply to everybody, and we have the right to know that we are being recorded. So if somebody agrees to that, then obviously that is. But for example, we know that many unscrupulous employers, they try to isolate you. They want to talk to you alone so you don't have a witness. But what we encourage workers to do is to create their documentation. So your employer just spoke to you by yourself and said, that they're going to cut your hours because they know you're causing them problems. You can text them and repeat what they told you, right? And you save that text, right? Or you could keep a journal with that information. And the same goes to protecting your wages, right? So records are necessarily to establish a wage claim, to establish what time you started working, what time you ended work, and what you were in fact paid, and you pursue that difference. So we also encourage workers to document. Just in general, that is a good practice to protect your job.
And so just basically keep a daily ledger is what you're saying.
Yes, that is correct. And then it's also good to include in there any injuries or any odd incidences that happen at work. Somebody came in and started yelling at you, just to protect against, even if it's not a legal issue, but it could be a disciplinary issue that you're up against. It's just a good habit to protect your wages, protect your job, is to document what happens at work.
Right. One of the things my dad taught me early on, just keep a little log of your hours, when you clock in and when you clock out for your break, when you clock back in after your break, and when you leave work. That way you have a running ledger of your time. So I think
Absolutely.
that's a good practice. So
Yes.
yeah, now, so we wanted to cut over to the generalities to identify retaliation. Okay, well, right now we have this special pandemic labor laws in position and activated. So how does that pertain to, are there any special retaliation laws pertaining to the COVID-19?
So they're not special laws, but there are laws that workers are possibly not very familiar with that we want to bring to their attention. And we definitely want to encourage folks to go on their website. We're going to give a brief overview here, but it's always a lot of detail in legal issues. And so one is our right to receive 3 paid sick days a year, right? So everybody has a right to paid sick days, and that accumulates with the first day on the job. You start accumulating sick time, and that equates to, for every 30 hours of work you get 1 hour, and you can access those sick hours after 90 days on the job. And you have the right, your employer cannot control when you use those hours. They can put a limit on it, and there is a limit that they can require you use 3 days within a 12-month period. Another statute we want to bring to folks' attention is there is a labor code statute that allows workers a release of time from work, up to 40 hours for employers who have 25 or more employees. And that time is to deal with a school emergency. So given the school closures, right, then you would be allowed, you'd have a right to have 40 hours off of work without losing your job. That is protected activity. Another one is you have the right to use, if your employer has a leave plan, you can use up to 6 months of accrued leave time to care for yourself or a family member or a child, or for preventative care. Okay. So that is also important for people to know. Now, the difference is that the executive orders and the local stay-at-home orders, those are protected. So if a worker believes that they are a vulnerable population and unable to go to work, and if they exercise that right under the executive order to comply with the order, and if their employer retaliates against them, fires them, or cuts their hours for refusing to go into work, they can file a claim with our office under retaliation.
Oh, okay. That's good. That's good. Now, you mentioned there, okay, how about if a person is working for, because we've got a lot of ag people and we have a lot of animal processing plants here. Mm-hmm. And what if someone has been working for a company for a bit of time, and I don't know if they have revealed that they have diabetes or not, but now that it's become an issue that they are being marked an essential worker, and they've found the virus in the plant, would that worker have a special, would they have an ability a little bit more to request not being in there because of their illness?
So I appreciate that question, and let me clarify that we are not medical experts. We are workplace protection agents. And so that is a question that they should refer to their local medical doctor and their local Department of Health to inquire and deal with their medical needs. But what the order does provide, the Public Health Department has provided some guidance, and they can find that on the websites that we've provided to you. Mm-hmm. If you are an essential worker, what that does is it exempts you from staying home. It allows you to continue working. The essential worker guidance does not require that you absolutely have to go to work. So that is something that workers should explore with their doctor with their local health department and with their employer to find the best path forward.
Yeah, because they don't want to lose their job, but of course, being in that situation, they don't want to lose their life either. You know, so
I
it's,
understand.
yeah, it's a little area that I'm like, oh my gosh, what do we do? But anyway, to go on, now you have what an essential worker responsibilities are to an employer. You kind of briefly touched on that just now, right?
Yes. So an employer, under the COVID pandemic, the governor has not loosened or lifted existing labor protections. So the labor protections are in place, which means employers still have obligations to pay workers on time, to pay workers no less than the minimum wage, to pay overtime, provide the breaks, etc. And employees have their obligations to follow the protocols that an employer has. An employer has a right to run their business. So we need to be mindful of this during this public health crisis so that we do not further exacerbate a difficult situation.
Right.
But if employers and workers, as I just stated, should review the guidance that's been provided by the public health authorities, and also the federal authorities in terms of the essential workers infrastructure to ensure that they have the proper information, and they could call our office if they have any questions or concerns.
What phone number would they dial?
We actually have our public information operators are up and running. They can call 1-844-522-6734. That's 1-844-522-6734. And people can also send us a question. If it's COVID related, they could send it to lco-covid-19@dir.ca.gov.
Oh, wow, that's wonderful. That's keep in touch with them. And then we talked about some of those other sites. It was dir.cal.gov, essential and non-essential workers. That has frequently asked questions for people. And then
Yes.
the labor.ca.gov, coronavirus.
Yes.
Okay. And then the other thing would be, we talked a little bit about the prohibition against discrimination if somewhere under the 6310 and 6311 labor code. And that has to do with folks that see hazardous situation and reporting that.
Absolutely. So those two labor code sections provide workers the opportunity to request personal protective equipment, to ask questions about the safety protocols, to seek assistance from any level of government about a workplace health and safety issue, and to not only ask questions, but also to complain to their supervisor or manager about any issue at the workplace. So that is an anti-retaliation statute. And so even though there is a sister agency of ours, CalOSHA, who actually enforces whether or not an employer is complying with, for example, protective equipment, personal protective equipment, right? The gloves, the masks, whatever your job type of personal protective equipment is required. The Labor Commissioner's Office is the agency where you would file a retaliation complaint if in defending your health and safety rights, you were retaliated against. Then you would come to our office to file that complaint. And in addition to the ones I reviewed, there's also Labor Code Section 6311 that says that you can refuse to perform work if in fact your working condition presents a real and apparent hazard to you.
Okay.
And so if you refuse to perform work and your employer retaliates against you, then you can also file a complaint with our office.
Okay.
Now, I do want to refer people back to our website because, again, these protections, there's a lot of detail in the law, and it's important that individuals spend time understanding it to ensure that they exercise it
Does it
best.
have written in the different languages?
Yes, we do have it in different languages. I apologize. I don't know off the top of my head. We absolutely do have like Spanish and Mandarin, Tagalog, but I'm not sure to the extent of all the different languages that we have.
Yeah, no, it was just a curious question because they've been doing pretty good. Here in Fresno, they did a couple of flyers and they had the major language, you know, Punjabi and Spanish and Hmong. And that I thought would be very helpful. So I know you're a busy gal and I don't want to keep you much longer. I think that Lindsay perhaps would be able to continue the conversation.
Sure.
And this program is set, it says meeting will end in 10 minutes. So
Oh, you have the limited one.
So, all right. So we thank you, Labor Commissioner Brower. Thank you so much for your time. And we appreciate you taking this few minutes to explain to everyone, you know, they are protected during this pandemic time, and there are ways to, if you absolutely feel terrified and cannot work because you have an underlying condition, you do have some wiggle room to get out of this situation for a period of time until you feel comfortable to get back to work. Alrighty. So we appreciate you and thank you and good luck with all of the work that you're doing.
Thank you so much. We look forward to speaking again.
All right. You take care.
Okay. Okay. Bye-bye. Thank you, Lindsay.
You're welcome. Thank you.
So hi, Lindsay.
Okay.
So
hello.
give us a little debrief of your background. Are you from Central California area or?
I didn't grow up here. I've lived here since 2016. I came to the Fresno area actually to work as a deputy labor commissioner with the Labor Commissioner's office. I lived in various parts of Northern California and worked in San Francisco with my law school clinic doing it's the Women Employment Rights Clinic. And I had some experience representing workers in wage claim adjudication hearings and processes with the clinic. And I really, we worked in the San Jose office and the Oakland office of the Labor Commissioner's office, kind of, you know, coming in as advocates. And I really admired the work that the Labor Commissioner's office did and how accessible the office was to California workers. So when an opportunity arose to relocate to Fresno, I jumped on it, and my husband and I, we've kind of fallen in. We really like Fresno. We like Fresno a lot, and it has so much to offer. There's so much. There's a little of everything, and people from all walks of life, and it's been really great. But yeah.
Good. Well, welcome. And there's room. I mean, if you have kids, at least you have a little more area to work in.
We don't yet, but our dogs really appreciate the space, and yeah, it's so true. Yeah, you get a little room to spread out in Fresno more so than in the Bay.
Okay, so we need to get through this quickly. Yeah. About 9 minutes.
Okay.
Now, one of the things that we were talking about, this paid sick leave. How can a essential worker who is suffering from a COVID-19 listed ailment decide to take a break from work in order to avoid contracting the disease? Kind of what we touched on ago. But do most of the employers, do they abide by this request? Do they understand that they need to?
They should. The paid sick leave rule has been in place for, I think it goes back to, I'm terrible with dates, 2015 or 2015. As far as there's a lot of nuances to it, but the long story short is, as the labor commissioner mentioned. It's about 24 hours a year, and employees have a protected right to use that time. And if the employer offers more paid sick leave than those 24 hours, then typically, depending on the policy, again, that's typically protected as well. I also wanted to take the opportunity to bring up, there was an executive order specifically for food sector workers. And this was in just this month, the governor's office. And we have information on our website, that same dir.ca.gov. So for food service workers working for companies that nationally have more than 500 employees, there's an additional requirement that the employers provide an additional 40 hours of work, or excuse me, paid sick leave. Again, we have a whole frequently asked questions section that kind of breaks it all down on our website.
So now, what typically a sick, now that gave a little touch on the allowances, like say if you're, how does this virus emergency change the regulations, the typical regulation?
One of them is that that the governor's executive order regarding food service workers. There's also a number of federal programs that have different names, it's like this different acronyms and names, and those programs are fairly new and were part of the CARES Act. And there's information on the labor.ca.gov. It's the state of California's labor workforce development site. It has great charts that can link you up with, if this is your situation, here's the program that might help you. So there's statewide, it's still the same paid sick leave provision, 24 hours, and your right to use those. And then in addition to the executive order, and I think people are using their paid sick leave more than ever before and kind of exploring how many hours they have and their right to use it. And again, we have information, and we also are available. You know, our public offices are closed, so people can call the main line. And then locally, we have a phone number. It's on the website, but it will direct you first to the Fresno office, and then if no one's available there, it will push you out. So
could you share that phone number? So
yeah, that one is 559-244-5340.
All righty. Now that has with the COVID. Now I heard, now I'm not working for an employer, but I heard for employee-employer relationships that they are getting paid, I mean, for the time off, they're kind of getting a supplemental pay because it's not, they're getting a little bit more than you're usually going to get on a sick leave allowance, correct?
I believe you're referring to, I think it's, the acronym is CFRA, or I think it's a program administered by the U.S. Department of Labor.
Oh, okay.
So and that's why it gets a little confusing, and we're definitely happy to help people on a case-by-case basis to navigate the laws and the information and direct them to the right agency if it's not us. So we enforce under the California Labor Code, the right to, the 24 hours of paid sick leave and that executive order. But if it's something enforced by under federal law, we can direct you to get, workers or employers to get information and assistance about that through those sites. We're not totally up to speed, and we're not the agency that enforces those, but we definitely understand how it can be a bit confusing.
Different layers due to the fact that you have your regular everyday administrative law that you're dealing with, and now you have kind of an adjunct to that. It's kind of like, because you're an XYZ employee, you have a right to, now I don't know, they were talking about hazardous pay. Is that something that's become an issue for the state of California as yet?
So the term hazard pay, there's not a provision in the California Labor Code that requires employers generally. Now there could be industry specific, but there isn't a hazard pay requirement, but I think where it becomes most relevant when it comes to hazards in the workplace, especially for essential workers, is those rights under 6310 and 6311 of the labor code, which is the health and safety provisions, to ask those questions, to raise the concerns, and to refuse to work if there's an existing hazard.
Yeah.
I think that,
we don't know. I mean, we just don't know what we don't know. I mean, that's what's happening every single day. Something is unfolding that's new and different, and we had no idea. I mean, who could ever forecast something like this craziness? And I can understand why we have so many people that have these theories and this, you know, this is a great mystique to this administration that they're doing this and that, and or it was pre-planned and G20 something.
It's unprecedented, but I can say,
Yeah.
you know, Lilia and the Labor Commissioner's Office, and we're under the Department of Industrial Relations.